Will you take roll, please?
Mrs. Butler?
Yes.
Mrs. Donahue?
Yes.
Mr. B?
Yes.
Mrs. Leskowitz?
Yes.
We're here. We're all here.
Yes.
Yes, yes, I'm here.
And you'll do the oath of office?
Wow. Okay, I'm gonna do the hard part. I'm gonna read everything, and then all you have to do is, if you agree, answer I do. Do you solemnly swear that you will support the Constitution of the United States and the Constitution of the State of Ohio, and that you will faithfully and impartially discharge your duties as a member of the Board of Education of the Bethel Local School District, Miami County, Ohio, to the best of your ability and in accordance with the laws now in effect and hereafter to be enacted during your continuance in said office and until your successor is elected and qualified? If you agree, please say I do.
I do.
Congratulations.
Natalie, your picture? Okay.
Picture, Natalie.
Oh, where would I have to get? Yeah, right here.
We can just wait until next week. I'll have something to read.
Thanks.
And speaking of pictures, we're gonna do them next Tuesday. The group photo. Speaking of next Tuesday.
I won't be here.
We'll do it, Mark. Good to know.
Yes.
Spring.
Now stand
Maybe a
for the
spring
pledge of
picture.
He's trying to say hi.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Can I get a motion to approve the adoption of the agenda?
I'll move.
Second.
Any discussion? You take roll, please.
Mrs. Donahue?
Yes.
Mr. B?
Yes.
Mrs. Amberly?
Yes.
Mrs. Butler?
Yes.
Mrs. Leskowitz?
Yes. Do we have any public participation?
Don't see.
Then we'll go right into our legal training.
Hi,
Hi.
I just wanted to introduce myself to you, board. My new client, my new boss. I'm John.
Hi, sorry.
And John Alton, my associate.
Hello, very nice to meet you guys.
Nice to meet you. Congratulations.
Thank you, I
Congratulations on your
appreciate it.
election. We were asked to provide some legal training on boardsmanship, some of your board policies, some of the rules. You gave us an hour and a half. You probably need about 6 hours. Knowing Mr. Nutter, after about 40 minutes, he'll be bored, so we'll have to cut it short. So as we go through this, Josh passing out a book. The slides are in the book. We don't intend to go through all of them.
Thank you.
We're also going to reference
Thank you.
some of your board policies. We built this around, as the board, you have determined how you want to have governance and operation. So this is specific for Bethel schools in terms of our presentation. Feel free to interrupt. Feel free to ask any questions. I've already had conversations with both Mike and Jenny. I'm hoping that they will contribute as well. There may be some things that you decide after this presentation you want to change in your board policy and do things differently. We can certainly talk about how that's going to happen. As a senior attorney, I get to sit here while John Alton is going to make the presentation with regards to the slides. So, and again, any questions, please let us know. Is it an hour and a half? Not the right time?
No, I think it's fine.
Hour to an hour and a half. We may not go all night.
I know, the audience is rolling their eyes.
Sure, love
Take what you need.
Well, we'll see as things go up. I need to speed.
I do have a former student right there. She needs an hour and a half timing. She's getting her teaching license. She's working on it. So she asked me, she's like, I need an hour and a half meeting. So
Oh, yeah.
Oh, well, then we got that
yeah. She got
All right, place.
Here from Jewish book.
There we go.
Okay. Well, again, thanks everyone for being here today and sitting through this presentation. There are a lot of interesting topics in this. I will try not to bore everyone as we go through this, but we're going to start off this presentation by getting my clicker working.
I don't.
Use this for now. I'll go get you a different one.
Now, you can see.
Okay, well, we're starting off the presentation by talking about boardsmanship and board policy. And when we talk about boardsmanship, really what we're getting at are best practices and rules for you all as board members to follow as you serve your terms here at Bethel School District. We'll be referencing some board policies during this part of the presentation that will guide you through this process, because while there are some guidelines from ODEW, you do have specific board policies that pertain to some of the specific things we'll be talking about. Going off of that, I want to quickly provide a note about the difference between your board policies, your administrative guidelines. Your board policies are the work of you five as a board. They're the policies that you set that tell parents, students, community members, employees, administration, how things in the district will go. They set expectations for the district. They are effectively the laws of the district. Administrative guidelines, on the other hand, are set by typically the superintendent and the treasurer, stemming from your board policies. They are the interpretation of how your board policies work and any other rules they believe may be necessary to execute those board policies effectively. As a general rule, you as a board don't set the administrative guidelines, but these guidelines stem from your board policies. Going off of that, I want to talk about the significance of following your board policy and the failure to do so. Your board policies, there are effectively two kinds. There are the board policies that are required by statute and the board policies that are not required by statute. Board policies that are not required by statute, you as a board are able and free to change so long as doing so doesn't conflict with current existing provisions of the law. When we look at the board following board policies, it's important not only to follow those provisions required by law, because doing so is effectively following the law itself, but it's also important because you as a board set the tone for the rest of the district. Failing to follow your own policy can result in censorship by the rest of the board. Thank you. Or in repeated patterns could even result in removal of office, albeit that's extreme. One or two mishaps is not going to result in removal, but it's important to follow what we're doing here, both from a legal standpoint and an administrative standpoint. Bylaws 0123. By the way, your bylaws are just the foundational principle of your policies and the 0 section of them. They're the policies that really guide all of the policies, how you set your policies, how you change your policies, and some pretty fundamental things for how you run as board members. But you do have a code of ethics at 0123, and your code of ethics is the more abstract, the fundamental principles you follow as board members. And the first two provisions from that board policy, I think, are good to set the tone for what really is going on as you serve your terms. The Board of Education believes quality public education and good board service should be conducted in an ethical manner with traditional principles such as honesty, trust, fairness, and integrity. Each board member should conform his or her conduct to Ohio law, the code of ethics recommended by the Ohio School Boards Association, and the code of conduct set forth as adopted from the National School Boards Association publication, Becoming a Better Board Member. Now, the next two slides have a lot of bullet points on them, about 24. I'm not going to go through all of these, but what you'll notice, even just at a glance, all of the bullet points on here will be touching on the different topics we're covering in this presentation. They'll cover on ethics laws, public records laws, your duty to communicate and how you interact with different people in the district. I want to highlight some of them from the outset here, looking at the OSBA Code of Ethics, respecting the confidentiality of privileged information. You as board members have a very important job and you handle a lot of sensitive and confidential information. It's important not only for your duties under Ohio's ethics laws, but also just for your practical duties as board members to make sure information you receive in your duties is kept confidential where it needs to be. Recognizing that as an individual board member, you do not speak or act for the board. The board is all five of you. The board is not necessarily each individual one of you. Individually, you cannot act for the board. As for speaking for the board president, we'll talk about that later, has the authority under a board policy to speak for the board, but the board is made up of all five of you. You will act as a majority, not as an individual. Delegate your authority for the administration of the schools to the superintendent, treasurer, and staff. Mike and Jenny are the two most important administrators in the district. They are responsible for ensuring the operations of the district. The board kind of sits on top of the mountain, if you will, and looks prospectively for the district to plan out what is going to happen in the future, to recognize issues that they need to tackle from a high level. But when it comes to the actual day-to-day operations, look to Mike and Jenny as the treasurer and superintendent and the many staff that they have working under them. Avoid conflicts of interest or the appearance thereof. This is really the heart of Ohio's ethics laws, and we'll get to that later on in the presentation. Conflicts of interest covers a lot of different topics. We'll talk about it more as we go through it, but when you think about things like nepotism or business interests, be aware of those as you go through your duties as a board member. I'm going to quickly highlight some other points from the second half of your code of ethics. These 3 points on the left: sincerely strive to build better relationships with one another and the superintendent, set goals for the superintendent, support the superintendent to be as effective as possible. These 3 points also apply to your treasurer as well. They just don't say that because these are directly copied and pasted from your code. But as I said earlier, Mike and Jenny are the 2 most important administrators in the district. They run the district and they keep abreast of all the day-to-day issues and operations that go on. Your relationship with them will not only ensure an efficient operations of the district, but it also helps you as board members keep abreast of the issues that are going on in the district that you wouldn't otherwise be able to know. You work with them and they work with you. This combination really helps you as a board member make sure the schools are operating efficiently. Going off of that, on the right-hand side, emphasize planning, policymaking, and public relations rather than becoming involved in management of the schools. This is the on top of the mountain approach that I was talking about. You work at a high level, you work forward thinking for the district, and then keeping abreast of current educational issues. Again, look to Mike and Jenny when talking through this. Next, I want to move to your communications as a board. First, your communications with your board council. There are no statutory or board policies that really guide how you as a board talk to us. One thing we do want to clarify is, as board council, we represent the 5 of you as an entity, not each of you individually. You are, of course, entitled to representation from us, but we represent the board as a whole. Historically at Bethel, which I may have been the past 32 years or so, the board president Jackie has informally been designated to solicit advice from us. That advice is then disseminated amongst the rest of the board members. But again, we are the attorney for the board. All of you are free to reach out to us if you have questions. With that said, the majority of our interaction with Bethel is to the superintendent and the treasurer. Again, they handle most of the day-to-day operations. When there are problems, they are the ones who reach to us.
I want to stop there. Every board of education has a chance to review the governance of communication. This is how we've done it for a while. That doesn't necessarily mean it's how we have to perpetuate it. You know, Natalie's been on the board 4 years. Three of you have been on 2 years. Kristen, like 2 months, month and a half. So, you know, over the years, I think I've calls from individual board members on issues. I think that's fine. Feel free to call us anytime that you want. As a general rule, a lot of our conversation comes from your administrative staff. It's a little bit more efficient that way. The other issue would be whether or not when I get a call from the board president, it's something that we should respond to in writing. Again, the good news would be, unlike some of the things we talked about under attorney-client privilege, everything that I send to you is confidential. So we unless you want to do something different, my recommendation is let's got to start out the way that it's been. And if we want to do something different, we can always revisit that. That's okay. Okay.
Staying on the topic of communications and boardsmanship, I want to address proper boardsmanship and working with the administration and with the public. A common theme that will be present throughout this presentation is Mike and Jen are important. When you do work with administration, staff, or you request information from them, be mindful of the fact that administrators' first priority is really to conduct the operations of the district. You know, the board is forward thinking. The board looks at everything from a high picture. Mike has to look at discipline from a teacher maybe this day. Jenny is looking at the financial forecast. When we do want to talk to the school district, just be mindful of the fact that they have to actually run the district during the day. If we do want to, as a board, perhaps conduct a more formal inquiry into issues, or there is a matter that we want to discuss more formally, it's usually best to do that as a board rather than individually as a board member. And when we look to communications with citizens, or rather receiving communications from citizens, typically it is best to send those communications to the superintendent. And then the superintendent will, if they deem necessary, issue a response. It's best for the district. Mike is the one who is typically the face of the district. He works with the community, he works with the teachers. When it comes to communicating with staff and students, typically the superintendent is best equipped to understand what to say and when to issue a response.
One thing I'd like to add to that, from time to time, board members get accosted at Costco and other places with a complaint. We do appreciate you follow that going back to the superintendent. However, you should have some opportunity to know exactly the outcomes of you giving that information to him. So, you know, otherwise, if nothing happens, then you're embarrassed a second time. And if something does happen, at least to have known. So in that case, if you're going to forward complaints to your superintendent, traditionally, you'll get some response. Here's what I did, you know, on behalf of that. And then usually goes to all 5 board members too, doesn't it?
Yeah, I mean, since I've been here, you all have been really good about, if you hear something or somebody got a question, you send it to me. I usually get back to you and say, this is what I said, or, you know, but I like updates from last week. You got 3 of them. They went to everybody, you know, just so you know. So when you're out in the community, you're gonna get asked. So you know what's going on. So you've been good about that. I try to get the things that I think you're gonna get questions about out. So
We appreciate that.
I've just labeled a phrase, accosted at Costco.
yeah.
I think I just rolled up. Sorry. Write that down over there.
Can I ask a question? Sure. So let's say if someone emails us a complaint, do we forward that on? Do I forward that on to Mr. Nutter, or do I put it in my own words? Like a lot of it has been either hearsay, like, or verbal, so I just type up the question or whatever it is, but I'm saying like, because I know we have to be very careful with email. So I don't know if I should forward, like if I get something in my email, if I would forward that, or if I put it in my own words and ask it.
Usually forward. If you get an email, just forward.
Okay.
Yeah, if you get something in writing, then this way there won't be anything lost in translation.
Okay.
If you get a phone call or I want to use a Costco third time, but somebody wants to ask you a question and you have to paraphrase it, that's okay too.
Okay.
And I will say, I do like to reply first and say, I'll forward this to the superintendent, or I'll look into it. I usually try to do something really brief, but I don't like it when it looks like I'm posting them, because they'll think, why haven't we got from, and now they're being ignored. So I do like to do that, and that's on a separate email, and then I'll forward the email. So.
Yeah, it works.
And maybe you're great, you answered my question.
Yes,
Response. I guess you- okay.
this is anonymous.
Moving on, then, I want to talk about expressing your opinions as a board member versus expressing your opinions as a member of the community. One quick note on this, when it comes to public expressions of members, I alluded to this earlier. You have a board policy that designates the board president as the official spokesperson for the board. So when media or other news maybe reach out to the board for opinion and comment on certain matters, Jack is the one enumerated under your board policy to speak on behalf of the board for those issues. If you do speak individually as a board member, otherwise, you want to represent that, you speak on your own behalf as a board member and not necessarily as the board, because that is vested in the board president.
I want to say just from what I've done, I always go to John and ask him what I can say before I ever look at it. And depending on what it is, sometimes we'll collectively solicit input from the whole board before we go out and say something. So I would never just go out and say, well, this is my opinion, but play with it.
And it'll come up, I think, a little bit later in our presentation. There's a difference between speaking on behalf of the board and responding to questions from the media. We've got those from time to time. Typically, our superintendent and or the treasurer are kind of trained to deal with the media. And so it's a general rule, if it's something that you can delegate down to the superintendent to respond, that's my recommendation, because I think it works best, but I think just as importantly, if it still blows up, then you're not the one making the statement. You follow the logic, that sort of thing. That's why I represent you, okay? Let us get against the wall. But and again, we can certainly change. Over the years, the president's done a really good job of making sure that when he or she makes comments on behalf of the Board of Education, typically it's best efforts that this is the feeling of at least the majority of the board. Sometimes you do have the option and the flexibility. Here's kind of what we put together, circulated. Sometimes that runs a little bit because we don't want to deliberate depending on the topic. But it's touchy, but I think here at Bethel, you really do it the right way.
Hang Mike out to dry.
Yes.
Double underline.
That's a summary of that, isn't it?
You can quote me on that.
Now you're on my own island. On myself.
That was awesome.
Well, and that brings up a good point though, too. So you're our legal counsel, right? But then you also advise Mike as well, right? Like,
We advise Mike because you direct us to advise Mike.
gotcha.
Yes.
He works for you.
He's not
Yeah, so-
our attorney.
That's
Georgia.
And as you know, we've been involved in the departure of superintendents and or administrators and treasurers in the district. So our loyalties are, should never be, it's always with the Board of Education.
Thank you.
Yeah, but
Yes, he's writing a lot now.
Yeah, but actually, and staying with that as well, attorney-client privilege, which really isn't part of our scenario. When you call and say this is attorney-client privilege not to be discussed with your administrative staff, it's not discussed with your administrative staff. A little bit more difficult when you say, don't discuss this with other board members, but at least for the administrative staff, that privilege exists.
Keeping on this same slide, I want to talk about speaking as a board member versus a community member. You are a member of the Board of Education, but you do live regular lives. When you are out and about and you're talking a day-to-day conversation with other members who happen to be in the Bethel community, most people are going to recognize you are not speaking to them as a member of the Board of Education. You're talking to them as a citizen, an individual person. But at times you need to be aware of the fact that because you are a public official, because people know that you are a member of the Board of Education, that when you do have discussions with people, sometimes when topics may be veered towards talking about the school district or perhaps talking to certain educational issues or otherwise that affect the district, when you do have discussions with people out and about, they may begin to look at you as perhaps speaking as a board member rather than an individual. Now, this is more of a common sense approach when you are talking with members of the public. Just be mindful of what you're talking about. But it is important, going off what we said, as an individual board member, you don't speak for the board. So we want to be careful about that in regular conversation.
And to piggyback on that more so, probably, because I'm a parent in the district as well, And I never want it to look like I am reaching out to a teacher and then they think that I'm coming to them as a board. So if I have a correspondence with any staff because of my kids, I always put it on my personal email. And then I always preface the beginning with, I'm coming to you as a parent, and then I'll go through whatever my issue is. If it were to be, if there was some kind of issue that had to go to the superintendent, I wouldn't address it to them. I would send it to Mike and then tell him what happened, and then those are his people and he would look at that. So I try to make that distinction as well, as far as parent community member.
Yeah, that's great practice. Moving then to individual board members' discussions regarding district employees. You do have another board policy on this at 0148.1 board staff communications. There's a specific provision in here that I believe best captures what this policy is getting at, and that is section C of that policy. It will be considered unacceptable conduct for board members to discuss individual personalities, personnel grievances, or other complaints with members of the staff. Instead, staff members should be encouraged to utilize the procedures established in board policy or the collective bargaining agreement to have their concerns, complaints, or grievances addressed. Really what this is getting at is if there are issues with staff that maybe you have with staff in the district or that staff in the district have themselves, and staff should not be complaining to the board about personnel grievances. They should follow the grievance procedure in the CBA or the complaint procedure in the CBA. That also applies for you as board members. If you have complaints or issues with staff at the district, you should not be discussing that necessarily with other staff at the district. You should also try and direct that to appropriate administration to follow the procedures that we have in place already under policy and with the CBA. And really with all the things we talked about, it's best anytime you have a question or concern, refer back to your code of ethics, because these are the fundamental principles that guide everything. Encourage ongoing communication amongst both board members and with your administration to communicate issues and understand what's going on. Refuse to become involved in micromanagement. You sit atop the mountain, Mike and Jenny handle the operations of the district. You work together to understand what's going on. Emphasize planning and policy making. Again, sitting on top of the mountain and looking forward to what is best for Bethel, its staff, and its students. And strive to build better relationships with Jenny and Mike.
And I'll interject there. I think our relationship is great.
Yeah, I'm not saying
Build
otherwise.
it better.
I don't know, Andy's over here really writing some stuff down.
It's a two-way relationship. They may not feel that way.
It's right.
But I've been part of leadership teams, like the seven of us, where going back to, I speak as, an individual and not as the board. Depending on what's going on, it can get very fractured. And so going back to that code of conduct and just remembering that, yes, all five of you, like when we're dealing with different things, like you are the board. Like sometimes people will say we're married to 5 people, like you're all equal, even though we have a president, vice president. Whatever we tell Andy, we're gonna have to tell all of you and vice versa, but it can get strained depending on what's going on. So I feel it's really great right now, but we just gotta keep to that.
But I mean, we've been doing this a long time. We know that these jobs are difficult at times, right?
Yeah.
So having a good board makes this job a lot easier.
Yeah.
So that, and like I said, I like it. Still here.
Your job's not
For 6 more years. You got it easy.
You have it on record. Instead of
Any other questions or comments on what we discussed about boardmanship and policy before we move on to the next section? Next, we're going to move on to the Open Meetings Act. The Open Meetings Act is part of Ohio's Sunshine Laws, which aims for transparency from public officials, public institutions, from the state generally. The Open Meetings Act for you all as board members is especially important because, one, the Open Meetings Act governs how you guys not only act as a board, but conduct your meetings. And second, the Open Meetings Act in the past few years has led to a good amount of litigation. So it's something to be especially mindful of. The core of the Open Meetings Act is that as a public entity, your public meetings are open to the public at all times, minus those limited circumstances under statute where you can meet in private. All deliberations conducted in open meetings, unless the subject matter is specifically accepted by law, the best example being executive sessions, which we're going to discuss in more detail later on in this presentation. Statute has a very specific definition of what constitutes a meeting. And I think it's good to go through the 4 parts of it because it helps you understand what we're aiming for with the Open Meetings Act and its various requirements. Under 121.22, a meeting is defined by statute as any prearranged discussion of the public business of the public body by a majority of its members. So there's really 4 pieces going on in this definition. When we talk about a prearranged meeting of the board, what we're getting at is chance meetings of 3 or more of you at, stick with Costco, are not a meeting of the board simply because a majority of you are present. It's not prearranged, it's just by chance. But with that said, because those meetings do happen from time to time, just because it's not prearranged does not mean you have free range to discuss board business. Even if it's not prearranged, you need to make sure that if a majority of you are present, you need to be having discussions of board business in public. The big threshold question here is when a majority of you are present, so 3 out of 5. And this can get a little bit dicey at times when we talk about discussions of the majority when it comes to things like texts and emails. Individual board members are allowed to talk with one another because in that situation, you only have 2 board members. That is not a majority of the board discussing board business. The problem then becomes if you have Jackie talks to Reagan, Reagan talks to Natalie, Natalie talks to Chris, Chris talks to Andy. Well, we have a bunch of one-on-one conversations, but all 5 board members are involved. That's going to constitute a majority of the board. You can't try and play around with the numbers here because you have different conversations. So when you do want to have discussions as a board, or perhaps you talk to one board member, you realize maybe this is going to lead to a larger discussion, make sure you communicate with the rest of the board in preferably asynchronous form of communication, and email is the best example. Maybe we need a special meeting, or maybe we need to talk about this at the regular meeting without further discussion. Because again, all discussions, public discussions of the public body in public. One other important point that we're going to talk about in more detail here is what constitutes the public body for purposes of the Open Meetings Act. This definition, of course, includes the board itself, but it also includes your committees and your subcommittees. So what this means is the Open Meetings Act is the law that requires you to maintain minutes, to post an agenda, to have this in public. All of those different laws and regulations apply to meetings of your committees and subcommittees as well. So when we look to the public body and its committees, one important thing to note, there's no definition of a committee under statute. We look to case law and the Attorney General. We're trying to figure out what actually constitutes a committee of the board. The Attorney General's guidance hinges on the origin of the committee in question. So if the committee is either A, required by law, rule, or regulation, or B, was created by action of the board itself, then it is considered to be part of the public body. It is subject to various requirements of the Open Meetings Act, public meetings, minutes, agenda, all of that. If the committee was created solely by district administration without the orders or approval of the board, then the Attorney General tells us that because of its origins, it's an administrative committee that is not subject to the Sunshine Law. However, an important caveat with this, case law from various courts has expressed disfavor if a board, in an attempt to take discussions out of public view, which they would otherwise be required to discuss in public, by pushing it off to a committee. So for example, even if you have a committee created by, say, school administration, where you have 2 board members sitting on it, it's going to be difficult to try and argue this is an administrative committee not subject to the Open Meetings Act because the board didn't create it. Meanwhile, you have 2 members of the board discussing what is virtually going to be business of the board that is ordinarily going to have to be discussed in public session. You can't try and get the workaround in because doing so is against the intent of the Open Meetings Act. The Open Meetings Act, I believe I said this, but I want to reiterate it if I did not. The Open Meetings Act, like many other laws pertaining to public institutions, is to be liberally construed. And in the case of the Open Meetings Act, liberally construed in favor of disclosure to the public, of openness to the public.
And I will say too, I have been in 2 districts where, I'm not going to mention the attorney's name. But
Well, you can say it wasn't me.
no, but there are attorneys out there who are looking for school districts to make a mistake on this. And then they will find clients in all of these school districts and they sue boards of education. And then all they're looking for is for you to settle and the attorney to get his attorney fees and to move on. And I've been in 2 districts and I felt like we had a pretty good standard by which we were doing things. But I can tell you, it was not a fun process, and we had to rethink how we did committees in both of those districts. And we had settlements with that attorney in both of those districts. So, yeah.
I want to segue off that because that's a great point, right? I want to add some more context to that. It's not on this slide, it is later on the presentation, but it's great to bring it up now. The Open Meetings Act it's unique under Ohio law in the sense that anyone can bring an action under the Open Meetings Act against the Bethel local school district, as long as they're in Ohio. Doesn't matter if they're up in Cleveland, if they're down in Cincinnati, or if they've ever lived in Bethel, they can bring an action to enforce this statute. And the statute is very easy to violate because even small technical violations can constitute a violation of the Open Meetings Act. One of the requirements of the Open Meetings Act is having accurate and complete minutes. You can go through a meeting, you can conduct it perfectly and properly, you can conduct your votes properly, everything's good. But if the minutes perhaps miss something that happened in the meeting, even if it did happen, the minutes are deficient. If the minutes are deficient, you violate the Open Meetings Act. And that's all good and well. The problem then lies in the penalties of the act. It's very easy to bring an action to enforce it. It's very easy to find a violation. And the penalties for the act include both statutory penalties, which include $500 per unique violation, and attorney's fees. And that's really the bigger part of it. In that, okay, you may have made a small mistake, perhaps in the minutes, or maybe in conducting the meeting itself. You have a statutory penalty of $500, but an attorney may spend dozens of hours going through a year or 2 years of your minutes of recordings of your meetings. And while the $500 forfeiture may seem small, you may have 10 grand plus of attorney's fees that you have to pay out for very small violations. Something you can actually do if you're curious. There's a label that's been put on these individuals. They're called Open Meetings Act bounty hunters by some news outlets because, like Jenny was saying, they scour public institutions and not just school boards, because this law applies to other public institutions as well, like municipalities. They scour their minutes. They look for these small little deficiencies that I'm talking about. They have a case and they can bring suit. It's pretty profitable.
So it has to be documented on a Word doc or whatever. We can't back it up with the meeting was also recorded. So if we by chance did miss something in the minutes.
I'm not the attorney, but I'm gonna say it goes back to your policy. And in one district, our policy, we changed to say that our official minutes were the recording and the written minutes were the administrative backup. But we did that after the lawsuit because we tried to say that. Well, we have minutes and then we also have the recording, but the policy said that the official minutes were the written and the recording it was a supplement. So we switched policy. I'm not telling anybody what to do. This is just from experience.
If you're all administrative committee, you don't have to worry about it.
Because they want to be subject to the Open Meetings Act.
But it's still for board
to go back to
board
that,
meetings.
part of the sunshine law says you have to approve the minutes. So if you do want to contemplate using video, that's going to mean 5 of you after the meeting are gonna have to look at the video. A good faith effort. It's not that you'll get a piece of paper with 6 pages, and you have to formally approve that. So you want to be a little bit careful. That's one of more hours of your time to revisit a meeting like now. You know, you don't want to have an interest in repeating. But remember, you need to have a roll call vote resolution for the specific minutes.
So the nuance with your point is that the minutes in a lot of school districts are officially the written minutes. They're not necessarily the video or audio recording. So the violation here is not that, you know, you failed to take the proper action. It's that the minutes themselves were deficient. And any questions on that? I know I just said a lot.
So if it's an administrative committee, you can have 2 or no? You can have 2 board members, or you say no?
No, the distinction here, when I talk about administrative versus board committee, subject to the Open Meetings Act, not subject to the Open Meetings Act. The origin distinction is, all right, administration creates it, no board of approval, no board involvement necessarily. That's an administrative committee not subject to the Open Meetings Act. But because of the spirit of the law and how it's liberally construed in favor of being open to the public, if you do have 2 board members sit on that administrative committee and say, well, we didn't create it, it's not a winning argument. Does that answer your question?
But you can have 2 board members on administrative committees if you choose, yes.
Okay.
It's just subject to the Open Meetings Act.
Then you need minutes.
That's if you have 2. If you have 1,
How about 1?
Yeah,
then splitting hairs.
well, you know, again, 2 for sure. Okay, again, going to the arguments that John raised earlier, you don't want to get in a situation where you're talking about things with 40% of the board that
Right.
you're no longer going to bring up to the full 5 of you. That's the whole idea of the transparency behind the sunshine law.
You know, the transparency piece would be if there are administrative committees that Jenny and I and our people ran, then we report back to you, right? Then the whole board hears and look for your feedback. Then there's no minutes, no agendas.
Yeah, again, the sunshine isn't illegal or illegal as opposed to a board meeting or administrative, it's requirements. And I think, as John said, those requirements are noticed, almost always open to the public, and minutes. Right. Are we taking questions from the audience? That's your call. Julie's got her hand up.
I mean,
Maybe at the end. Okay.
Unintentionally, that's fitting. Let's pivot into public participation at board meetings.
You guys practice this?
One little nuance here. The Open Meetings Act I've been referencing doesn't itself create a right to speak publicly at a meeting of the board. In addition to that, it doesn't give members of the public an absolute right to remain in attendance at a public school board meeting, regardless of their conduct. You know, you can, if people are disruptive or engaging in, well, other disruptive conduct, you can remove them. There's not an absolute right to remain here. However, school districts can open the door to public participation by passing a board policy that allows it. Bethel has done this. You have a board policy that board policy 0169.1. You allow public participation during both regular and special meetings. What this does is, under the law, you create something called a limited public forum. It's a very specific definition, but really what you need to know from that, what that means is you've now opened up public participation to First Amendment protections. You can give time and manner restrictions on it. You can set time limits. You can have it so that they can only participate at certain times, but you can't restrict them from participating based on certain viewpoints or based on the content of what they're trying to say. Moving on from that, we'll now talk about the 2 different kinds of meetings. I believe I've referenced this a few times, but it's good to get into the specifics. Generally speaking, you have regular meetings and special meetings. There is an organizational meeting that's held at the beginning of the year, but practically speaking, you have regular meetings and you have special meetings, and there are very important requirements that are different between the 2 of them. With your regular meetings are almost always set at your organizational meeting. This occurs in the first 15 days of the year. Among other things, you appoint your board president and your vice president. You fix the time for holding your regular meetings, which are to be held at least once every 2 months. That's not a problem at Bethel, but the absolute bare minimum is once every 2 months.
Not a problem here. Sometimes I like to even double up.
Remember, they get paid per meeting, I'm just saying.
The more important discussion we had here is with special meetings. And this has been another sore spot for litigation under the Open Meetings Act, particularly as it pertains to notification for special meetings. There's a lot of nuances here, so I'll try and go through it at least at a good pace. But you do have two board policies that are relevant here: 0165 board meetings and 0164 notice of meetings. Your board policy for your board meetings states: special meetings may be called by the board president, the treasurer, or by any two board members by serving written notice of the time and place of such meeting upon each board member of the board at least 2 days prior to the date of such meeting, signed by the official or members calling the meeting. And you can send that by mail or email. 0164 notice of meetings states that, and the OMA requires, that certain news media must be notified at least 24 hours prior to any special meeting, except in cases of emergency, of course. The particular news media to be notified are those media which have previously requested notification of special or emergency meetings, and your policy also requires you to post this notice on your website as well. The important point, which I've bolded and underlined: failure to timely notify the news media in accordance with the Open Meetings Act and your board policy will render the meeting illegal and void unless it is for an emergency. It is very strict. This 24-hour requirement, if even 23 hours, if you do not get the proper notification out, any deliberation or action during the meeting is void. And it's a violation of the Open Meetings Act, which leads to the penalties we talked about before. Another point on this, I don't believe I have this in the slides, but I need to mention it. This is not a problem at Bethel, but what I just talked about also applies to having a proper method of notification for getting out to the public. So like I said, you have a board policy, you send it out to the news media, and you send it out on your website as well. When you send notification, some districts have gotten hit under the act because their policy for sending out the notification was deficient. They did send it out 24 hours beforehand and they had the proper timeframes, but the method they have wasn't enough. And so it led to litigation and an eventual loss.
And even though we call this a work session, it's still a regular meeting because we did it in order. Is that right?
Correct. Yeah, the work session is a helpful label to understand the purpose of the meeting, but if it's scheduled the organizational meeting, it's a regular meeting. Same thing goes if you have say for example, you don't have it on your current schedule for meetings. Say you want to hold a work session on Wednesday of next week, you'd have to have that be a special meeting, and then you have to do the notification requirements and all of this. Even though you're calling it a work session, it's still a special meeting. Another point on special meetings, and something to say on this as well. You guys work with Jenny when you send out all of these notifications and you work with the timing on this. So don't think that each individual one of you has to bear this burden of, I need to make sure it's perfect, I need to get it out within 24 hours. You work as a board, you work with Jenny. You guys will be good as long as you work together on this. But
Or then, let's throw Jenny in the bus. Okay?
Got it.
Yeah, okay.
Noted.
But so in addition to these requirements for the timing of the notification and where you send the notification to, there are requirements for the notification itself. The notification that you send out has to state the time, place, and purpose of the meeting. It has to include sufficient information so that it will enable anyone in the public to understand what is going on at the meeting. It doesn't have to be necessarily verbatim, but it needs to have enough specificity so people know what's going to go on. Furthermore, the notice that you send out has to state all agenda items that are going to occur at that meeting. And what I mean by that is at a regular meeting, so like this one, you guys sent out an agenda. We saw the agenda. But if you wanted to, during this discussion, you could add another topic to talk about that wasn't sent out, or 2 or 3 or 4. With a special meeting, when you send out the notification that has all, I'll say 5 things you talk about, you are stuck with those 5 things. You cannot add a 6th, 7th, or 8th. You are stuck to those 5. If you try and do something else that wasn't in the agenda, whatever action or deliberation resulting from that or during that is illegal and void, a violation of the Open Meetings Act. That's one of the more important things about special meetings, because I think some boards have simply gotten caught up in what they were doing and didn't realize maybe they wanted to take action based on those 5 things they talk about, but that action was a 6th item, wasn't on the agenda. So we need to be very careful when you send out these agendas, you stick to them.
Common trap of that, and I think Jetty knows this. You have an executive session for personnel. Then you decide you're going to come out of that executive session and hire somebody. That resolution isn't on the special meeting, and you're not going to hire that person. So, sometimes you just got to put all that together. If you have the executive session, you can decide we're going to hire this person, but you can't do it come out. Because it wasn't on the
special.
Especially if it didn't happen during regular.
Anything
then
goes.
we could, then-
Yeah, literally
You can
anything.
walk things on, right? Just not- Typically, we try not to do that anyway, but.
Right.
Any questions on the specifics of any of that as pertains to special meetings?
The other thing I wanted to mention too about the notice, we also, if members of the public request to get the notices of the meetings, I have a list of the people who get those notices. So when we send the email out, they are also added to that list. So anybody in the public could request those notices and they get that as well. So.
And so when you say if we did some business, like the special meeting had 5 items, we added the 6th and say it was to hire somebody, we did the hiring, that hiring would not be legal and we have to put it on the regular board meeting agenda, correct?
Correct,
Gotcha.
correct.
Yeah, whatever's on the special, it's always on special.
Yeah, remember, you can remove.
Mhm.
You don't have to take it, but you just can't add.
Yeah.
Now, if I send out the notice and you decide you want to take action and it's 24 hours, at least 24 hours in advance, I can modify that notice and send a new amended notice out. I've done that throughout my career. Send out an amended notice and say, we're adding the action.
That's the advantage between the 48 hours to you and the 24 hours to the media. If you see something on that advance notice, as Jen said, wait a minute, A, B, C, or D, she still has a legal opportunity.
When I talk about a quorum of the board and voting, quorum is just the majority. For school boards with 5, it's having 3 people present. But there are some nuances with it. When we talk about 3 people present physically, you can't call into a meeting or you can't Zoom into a meeting and be considered present. You could Zoom in and call in and listen, but you won't be considered to be here. You won't be able to take action unless you're present. Going off that nuance, for voting, similarly, voting is to be done in person and it's to be done by roll call. It's not to be done by a secret ballot, affidavit, proxy, in writing, or other indirect means. You have to be here, you have to say yes or no in order to do it. You can't slide a piece of paper or anything like that. School boards have tried. No, absolutely not. Another note on here, there's no exceptions made for a pandemic or other emergency. I know during the pandemic, a lot of what I just said maybe was relaxed. Those times are well behind us. There are no exceptions to this anymore. And then as well, typically, action by the board requires a simple majority, but there are some specific situations that require 4 of 5 votes. The biggest example being if you as a board want to place a tax levy on the ballot, you need 4 votes. There's a longer list. I don't have it down, but every now and then there are some specific actions where you do need 4 members to vote.
I think it's in our bylaws too. I think there's a whole table.
It may very well be.
There is.
I think so.
Additionally, you are expected to vote if you're here unless you have a legal conflict against doing so. You're not required to, but you are expected to.
And that'd be abstaining, right? That's the situation. where
Correct.
abstaining.
You can abstain, but generally speaking, you're expected to vote unless.
kind of silly. So if you miss a board meeting, you're not here, you can't vote. When you go to the next board meeting and you vote to approve the minutes, do you vote for that? Because you weren't there? You do? Because you're supposed to review them?
You don't have to be there to review the minutes after.
Yeah.
Briefly, we'll talk about the minutes. Again, these are more so the prerogative of Jenny as treasurer, but as I said, they're still important to discuss because they can constitute violations of the act. They are a requirement under the law. The minutes of any regular or special board meeting must be promptly prepared, filed, and maintained and open to public inspection. And I do want to note, this also requires the committees as well, as we talked about earlier, because they're considered part of the public body. Your minutes are not required for executive sessions, which we'll talk about on the next slide, but the minutes of the meetings where the executive sessions occur must reflect the general subject matter of what was discussed in that executive session. Typically, that applies to what the reason for the executive session was. The minutes have to be rendered with sufficient detail to permit the public to understand and appreciate the rationale behind your decisions as a board. They don't need to be verbatim, but they can't be overly general. And note that, and we talked about this earlier, about video and audio recordings. Those are not substitutes for the formal minutes. When you do record minutes of the board, they are your formal written minutes.
If you take minutes with AI, do they need to be transcribed? Can they be used directly as they're recorded by AI?
The
Or do
requirement,
they need to be
the requirement
interpreted?
for recording minutes rests with the treasurer. Right? Jenny has a legal obligation to make sure that a person who's not at the meeting to get the general important substance of what was discussed, voted upon, dissension from reading the minutes. Sure, she can do AI if she wants to assist her instead of taking notes, but it's still her responsibility to convert whatever she's given, from the internet to what she believes to be true and accurate reflection.
You're probably talking about the meetings that we go to, right? You see
Well,
the
I'm
notes
talking
come
like
up.
Otter or Fireflies or.
Yep, read
you know,
AI.
Yeah,
I could use that to help
right.
prepare them,
It needs to be
and it would
interpreted.
probably make it way more efficient. But that could not be the
Used as-
official.
Well, it's the same problem with the video. All of a sudden now you got to read 2 hours of AI chat.
Yeah. I was just personally interested in how it translated into official minutes.
Well, oddly enough, AI could give you a summary
I know,
if you want to trust the summary. Okay.
yeah,
Because I think that's her domain. So
yeah. I was just interested in how it translates.
Because there's a lot of those out there, like a lot of our media, they come on, they highlight it,
All the Zooms.
prioritize it, all these things.
Yeah, they pop up when you log on.
So minutes are her responsibility regardless if it's a board meeting, a special, or a regular meeting, a special meeting, or even a committee, right?
yeah, well,
That-
I want to be clear. If she doesn't go to the committee meeting, she can't be responsible for taking minutes. So someone who's going to be at that meeting has to
That's
take
good.
the minutes, refer them back to her. Q&A, it's a little bit hole in the statute, but nevertheless, those minutes do have to be maintained.
But I will say, I am officially the secretary to the
Yeah.
board, so even if I'm not there taking those minutes, the responsibility lies with me. So if it was a board committee, I'm gonna have to be there.
Probably.
Next, I want to talk about executive sessions. This is the big exception to the public discussion piece of the Open Meetings Act. Before you as a board can hold an executive session, you have to conduct a roll call vote of your members. You need a majority vote to then go into executive session. Executive session may not be held unless the motion for the executive session states which one or more of the subjects for the executive session are to be considered. When you do move to go into executive session, essentially you're going to give a verbatim statement, what the exception is under the statute, and there's 8 of them. Next slide. There's 8 exceptions under statute. I've been paraphrased here just because It's a lot of text to put out there, but you will verbatim state, we're going to executive session for 12122 G1, and then write out what it states, 12122 G2, and then write out what it states, and then go into the session. One caveat to that, because there are 8 reasons for them. They're all valid to go into executive session. You state them verbatim. With G1, it's 12122 G1 is the site for it. I have it paraphrased up here. This provision talks about basically all the actions you would take for an employee, public official, or other individual, whether you want to consider hiring them, demoting them, taking other disciplinary action against them. It's a very long provision that lists a bunch of different actions. With this one specifically, you are expected to specify which of those actions you're taking. So if there's 20 different actions you could take in G1, you can't put all 20 of them into the notice to go into executive session. You need to state 3, 4, 10, or however many you reasonably expect to go into there for. This was another nuance because of these 8, G1 is the only one that you have to modify the statement a little bit for. But there was a lot of litigation over this because a lot of school boards were skipping over that, and all of them got hit with a violation of the Open Meetings Act because the statute requires you to specify which of these 20 or so reasons you were going into for this executive session purpose. Additionally, you can't just quote all 8. Some boards have tried that every single time they went into session. You can't do it.
Just in case.
For a coverall.
Yeah.
However, with that said, you can, although it's not necessarily advised, you can state multiple reasons for going to executive session. Generally, it's best practice to segment them because when you go into executive session for multiple reasons, say you state 3 of them and you have 3 different discussions, maybe sometimes you run awry and realize you stepped into a 4th subject, or because you're touching on so many different discussions, you just end up discussing something that was not covered by the 3 reasons. Generally, you want to say 1 at a time, but you can state multiple. When you do go into executive session for multiple reasons at a time, so say you go into for G3, 1, and 2, and say you talk about the reasons for G3 conferences with an attorney, but you don't end up talking about 1 or 2, that's fine. You don't have to discuss all the reasons you went to executive session. I believe I touched on this, but to clarify more, it's important once you go into an executive session to adhere to the purpose of the session. If you go outside the scope of the purpose for the executive session, you've conducted an illegal deliberation. So if you go into executive session for G1 purposes of employing a employee at the district, and part of the way you're discussing through, you start discussing litigation that the district is in unrelated to employment of a employee of the district that exceeds the stated purpose that you went to executive session for. Any actions that will result from that deliberation are illegal and void under the Open Meetings Act, which is again a violation, which means penalty and attorney's fees. If you're in an executive session and during the session, you realize, going at the example I talked about, you're in there for employment of a public employee and you go, I think we need to talk about litigation. You need to leave the executive session, come back into regular session, state we're going to executive session for G3, conference with an attorney, discuss imminent court action, and then you go back in. You can't expand the executive session when you're in there. You need to come back to regular session, state it, and then you can go back in. As for the discussions themselves that take place during the executive session, the Open Meetings Act itself doesn't actually prohibit the disclosure of them, but Ohio's ethics law does under a separate provision. Under Ohio's ethics law, it is unlawful for a board member to disclose information which has been designated to him or her as being confidential, and preserving confidentiality is necessary to the proper conduct of the board's business. A good example for this is if you go into executive session for purposes of discussing union negotiations. Oftentimes there's a lot of very specific or hidden details the union shares with you and you share with the union. Those details are confidential and you can't come out of executive session and then share with the general public all of that information because it's understood to be confidential.
It's also unfair labor practice.
Yes, because it's in the context of union negotiations. Discussed the penalties earlier, but just to quickly recap them, there are three possible penalties: invalidation of action you take as a board, issuance of an injunction by a court, and then of course the monetary penalties and attorney's fees. A quick breakdown of how board action would be invalidated. Generally, it is illegal deliberations or insufficient notification of meetings. An insufficient notification includes both failure to adhere to the timeframes or failure to establish a reasonable method for notifying the public. Any questions on anything pertaining to the Open Meetings Act or the executive session, penalties, anything we just discussed in that section? Okay.
Before you continue, we've got two big topics left. One's public records and the other is Ohio ethics law. And I know you wanted to preserve some time for general questions that you can ask the two of us. And I know you want to talk a little bit more about the composition of committees. So this has been a little bit over an hour. So between the two, we've got time to do both. But if you wanted to shorten this, and you wanted to pick either public records or Ohio ethics law, the remaining information is in your file. So thoughts? Should we just keep going?
Yeah.
Okay.
We're not quitters.
Yeah. Quitters never quit and quitters never win.
We're just making sure your eyes aren't.
You know how long some of these meetings we've had?
Oh,
When I first got here.
You're just
yeah,
now
it's
telling
been
me
better.
this?
Marathon runners here.
It's gonna be a long one for me.
2 hours, are you kidding us?
That's all you got?
But we can make it longer. I can talk about more topics. Okay, we'll move on to discussions of public records. I want to say from the outset, ultimately, public records are more the responsibility of Jenny as the treasurer, because she is the records officer for the district. She's the one who's responsible for responding to public records requests. But as board members, you guys will inevitably get records requests from time to time. So it's good to understand some of the principles behind public records and the district's responsibilities for responding to them. I want to start off by talking about what qualifies as a public record. It is very, very complicated. The definition is simple, but there is a long statute that outlines many exceptions to public records. But talking about the foundation of what constitutes a public record is defined under statute, under the Public Record Statute 14943, as records kept by any public office, including school district units, which is very short and doesn't really capture the nuances of what this has evolved into. Bethel does have a public records policy, 8310, and it provides a more detailed definition that mirrors a separate statute, 149.011, which states, any document, device, or item, regardless of physical form or characteristic, including an electronic record, created or received by or coming under the jurisdiction of the board or its employees, which serves to document the organization, functions, policies, decisions, procedures, operations, or other activities of the district. That covers a lot of things. And practically speaking, public records has been interpreted to give the public access to virtually all kinds of records that the district holds, absent exceptions under statute. And there are dozens of exceptions under statute for what is not a public record. We're not going to list all of them out. There are many of them, but there are some that are especially important to school districts. These include medical records and security records, confidential law enforcement, investigatory records, privileged information such as attorney-client, doctor-patient. That includes, of course, your communications with us. Those are not public record. Criminal record checks. So record checks your employees conduct when they go to employment here at Bethel. That is not public record. And then most student records, the asterisk being what is called directory information. Directory information is really just yearbook information. So a student's name is not considered to be, a student's name is a public record because it is directory information for a student. Directory information is public, the student's name, anything you put in a yearbook, that can be disclosed. But other information about a student, education records, grades, discipline, none of that is considered to be a public record.
I think grades are now part of directory information. I'm not mistaken, aren't they? Trying to think, I kind of just saw, you're better off not giving grades, but I thought somewhere there might have been an exception to directory information. I don't know, but
I'm not sure right now.
I'll check it.
See, yeah.
Don't they don't they have the opportunity to sign an exemption?
Well, they
And if
do.
they sign, they don't want it disclosed,
Correct. You can opt out of directory information being
Okay.
disclosed.
so then it is not shareable, I guess.
To walk through the proper logic,
Yeah,
by default, directory information is a public record.
right.
But they can opt out of directory information being shared, in which case it is not a public record.
We have to go through cross-reference.
Yes, I know, I used to have to keep that spreadsheet, yes, no, picture, the whole thing,
Yep.
picture, yes,
No.
no, yes, yeah. It's so fun.
Oh, it is.
We've got a pretty detailed policy on student record information.
If you're doing video one day and the kids actually walk by and I'm like, well, we're going to that video.
Cutting room floor,
Redo.
okay,
Outside of the many different exceptions enumerated under statute, there are some other more general exceptions. A good example being personal and private notes. Some examples being notes kept by, so here's board member, notes kept by you for your private use, notes taken by a fiscal officer to prepare minutes of a public meeting, and the notes and comments of individual board members used to form a composite evaluation of their superintendent. These will not be considered public records. They are your personal and private notes. This also extends to, more common example, you're a teacher in a classroom, you have a notepad with your own personal things unrelated to students or perhaps education, you keep it in your desk drawer. Well, you're a public employee, but those notes are not public record. Additionally, unsolicited materials received by the district are not automatically public records just because they come into the district's possession. So for example, if you get an angry email from a parent, perhaps they're upset with the teacher, they just don't like them, they think they're ugly, etc. That doesn't become a public record just because you got it as a district. You have to take some action to either keep it, maintain it, or use it for some purpose for it to become a public record. So if I sent the district 100 different emails of gibberish, those aren't public records unless you decide to keep them for some purpose. Next, I want to talk about your communications on personal emails and devices. So one thing I want to say from the outset, because I'm sure you guys have personal phones and emails, those are not public records simply because you guys are board members for a political subdivision. However, text or emails that you guys have on a personal device or a personal account can become a public record if they document official board business. So it's something to be mindful of if you are texting from your phone, maybe to someone else on the board or perhaps to someone else in the administration on official business of the board, that record can become a public record. And if it becomes a public record, you have a duty to either retain it or move it to somewhere in district storage, district email, or whatever other digital storage we have to make sure that record is preserved. Say this from the outset. Jenny is our record officer. She is the one who has the fortune of responding to all public record requests. In this case, if you as a board member get a public records request from someone, or something that looks like a public records request, don't ignore it. Send it over to Jenny and she'll be the one to respond. Don't respond as a board member. There's a lot of nuances that go into it. Ultimately, Jenny is the one responsible for issuing these responses. Some more specifics regarding public records requests. One thing that I believe board members and perhaps the chagrin of others don't like is that anyone can make a public records request for any reason, with very limited exceptions. A person cannot be required to establish a proper purpose or any purpose for a public records request, nor can a public office require a requester to disclose their identity or to make the request in writing as a condition of granting access to public records. While you are able to ask for that information, you have to advise them that it is not mandatory to disclose. So generally speaking, if you don't ask, it's not a problem. If you do ask for that information, you need to tell them that it's not mandatory. However, there is a special exception. So I know I have a bullet here. We talk about limitation that the record isn't put in danger or others are not put in danger. That's very extreme. It doesn't come up very often. The bigger exception is in the case of student records, going back to directory information. Ohio has a separate statute that prevents student information from being used for a commercial purpose. What this means is specifically when student directory information is being sought or student information is being sought, then the requester may be required then to provide their identity and the intended use of the information. It's a very limited exception, but it does come up in schools because it applies to student information. Outside of that limited exception, outside of extreme circumstances though, anyone can request a record for any reason.
I responded to one today and said, to whom it may concern, because the email address was a very anonymous email address, the requester. So.
How many hours?
The other thing too,
More than I preferred. but-
Jenny and I have a couple of these. There are organizations, from Texas, California, they send out 100,000 emails looking for a lot of documentation. Who knows what purposes they're for? There's no website. You can't go and figure out, is this a profit making scheme? Is this a grad student, trying to get an A, being studious? And so, we get an awful lot of those. And when it's ambiguous, when, the information is too broad, when it's unclear, we can respond back for clarity. Oftentimes, that's really all we need to do. But again, there's been a whole just wave of institutions, organizations. I mean, they want your vendor list. They want to list all of your employees. They want to list them years of service of all your employees. They want to know what, you just keep going on and on and on. And keep in mind, when they call it a freedom of information, request for information, it's really a request for records. So if you don't have that record in existence, you're under no legal obligation to manufacture one just to satisfy the request. Plus if they do they request a particular format that you don't have, you're not required to develop it in any sort of, Excel or whatever sort of a format they're looking for.
One clarification I want to add on that. Public records requests are requests for records, not information.
Yes.
That is the heart of what
Yes.
we're talking about. We don't have to make something else. We don't have to change it into something else. And if you're requesting information for which we have no documentation, we don't have a record to give you. They also touched on a overly broad request too. We don't have an obligation to immediately respond to overly broad requests. As a district, we're supposed to respond and say that it is overly broad and help them try and modify the request to be more specific. But an overly broad request that asks for all financial information, we do not have to respond to from the outset because I have to give them an opportunity to cure it.
We've had a couple of situations in Bethel where from time to time, the media gets a hold of a rumor about an employee and they contact our treasurer's office or board members at 10 o'clock in the morning, and they want it for the 6 o'clock news. It won't be newsworthy tomorrow. But again, so the immediacy, okay, the statute uses the word, I think, John, promptly, if I'm not mistaken.
Yes.
So, sometimes when you get those sort of requests that they want an hour or they're outside waiting for the personnel file, that sort of thing. It's because it's a reaction that the media has their own deadlines. The good news is their deadlines are seldom our deadlines. We've had a couple of those here, as you know.
Any other questions or comments on public records before we move into the ethics law?
We're good if you're good.
Yeah. Do you need water? Are you getting it dry?
I got caffeine. One important point I'd like to make from the outset of the ethics law. Ethics law it's a little bit more ambiguous than other topics we talked about here, because whether or not something is an ethical violation isn't always clear just on the nature of how ethics law works. However, ethics law for you as board members can carry hefty penalties, including not only financial penalties, but it can also lead to jail time in certain violations of it. Ohio's ethics law. What a great note to start off.
I've never told them that. You want to run for office again, okay? Not to go to jail.
Really, the point of that is, if you have a question about ethics law, let us know. There are
Yeah.
stakes to it.
It's like, ask the question.
Ohio's ethics law generally covers two big topics. Those are conflicts of interest and then gifts and donations. We have an ethics commission. They're the one responsible for managing the ethics law. They're the ones who give us all the opinions on how to interpret it. And it really stems from 3 different statutes, which I will now talk about in order. One note before that, though, we want to talk about financial disclosures. The superintendent and treasurer of school districts have to file financial disclosures and keep updating them on file, listening what their business interests are, or what finances that they have, like stocks and other things of that sort. You as board members at Bethel don't have to do it, because for board members to file financial disclosures at school districts, there is an enrollment threshold of 12,000. So as far as I know, Bethel isn't approaching
Not yet.
12,000 anytime soon.
You're trying.
So they have to file financial disclosures. You guys do not. I get that note. Then a quick comment on the commission scope, and these are the 3 different sections we'll be talking about. The Ohio ethics law, of course, applies to you as board members, but it also applies to employees of the district and administrators of the district. So as we talk about the different conflicts of interest and nepotism that we're going to be discussing, these same things apply to Jenny. First few provisions I want to talk about come from Ohio Revised Code 102.03. There's a lot of different provisions in here that do different things. For example, I don't have it on the slide. I mentioned earlier, the ethics law prevents you from releasing confidential communications. That's covered under 102.03B. D, E, and F cover what I'll call the substantial and improper influence issues with Ohio's ethics law. I'll read them in turn. Paraphrasing. No board member shall use the authority or influence of their office or position to secure anything of value or the promise or offer of anything of value that is of such a character as to manifest a substantial and improper influence upon the public official or employee with respect to that person's duty. No board member shall solicit or accept anything of value that is of such a character as to manifest a substantial and improper influence upon that board member's duties. No person shall promise to a board member anything of value that is of such a character as to manifest a substantial and improper influence upon that board member's duties. You cannot use your position as a board member to get anything of value. You cannot use your position of a board member to solicit something of value, and other people cannot offer you something of value that is of a nature to have a substantial and improper influence on your duties as a board member. These 3 principles cover a lot of different parts of the ethics law, but as a foundation, when you are a board member, you can't use your position for personal financial gain. It covers more than that, and as what constitutes personal financial gain, there are a lot of different things that make that up. But a good example is, while of course, personal financial gain includes a $1 million check, it also includes things such as a promise of employment somewhere else. I'll skip over the bottom half of this.
No, you had a question.
No, I'm good.
Okay.
I was thinking of something else, sorry.
I'll skip over the bottom half of this slide. 292.43 is the supplemental compensation provision. As a board member, you get payment from the district, not from anyone else. That applies to all employees. They're paid by the district and no one else. That is the core of the supplemental compensation provision. It's not as relevant for board members as it is for individual employees. 2921.42 is the public contracts provision of Ohio's ethics law. It states, no public official shall knowingly do any of the following. 1, authorize or employ the authority or influence of the public official's office to secure authorization of any public contract in which the public official, a member of the public official's family, or any of the public official's business associates has an interest. This is very broad. It not only covers you, it covers your family members and business associates, and it covers public contracts with the district. And the definition of a public contract is also broad. Is really anything of financial value, large or small, with the district. It can cover, of course, the large construction contracts that you have. It can cover smaller things, maybe like fees or other favors. But it applies to you, your family members, and your business associates. Business associates has a more technical definition that I don't believe is relevant. Family members has a more robust definition that we'll get to in discussions of nepotism. I believe 2 slides.
But if they have a question about any of it, this is where like conversations with legal counsel.
Yes.
Who would pick up the phone and call.
Yeah, again, because of the penalties under ethics laws, don't take risks personally, don't make assumptions personally, because even if you do even if you do have a grasp of how the law works, there are many ambiguities that come up with this that may not be readily apparent. Talk it through with us. Before we discuss nepotism, I do want to point out, you do have the board policy on this. It's 0141.2. It's an overview of Ohio's ethics laws as it pertains to conflicts of interest. It's not comprehensive, but it's a great rule of thumb if you do have questions. Conflicts of interest, as explained, this involves you, your family members, or business associates. And I'll get into the second point when we discuss nepotism. This law prohibits you as board members from participating in decisions regarding a family member's employment, both before and after the actual employment. The definition we have for a family member, as provided under statute and under later opinions of the Ohio Ethics Commission, includes the following relatives regardless of where they reside. Where they live is relevant for the latter half. Your spouse, your children, whether they're dependent or not, siblings, parents, grandparents, grandchildren, both stepchildren and step-parents, regardless of where they live. It further includes any other person related by blood or by marriage and living in the same household. So that would extend to in-laws, but that depends on where they live. So in-laws.
If they have to live with you? If they're living with you?
So in-laws and others related by blood or marriage, it depends on where they live. Spouse, children, siblings, parents, grandparents, grandchildren, stepchildren, step-parents, regardless of where they live. So when we talk about you're not allowed to participate in decisions regarding family members' employment, participating in a decision can take many forms. Obviously, we think of voting on a family member's employment. You cannot vote on a family member's employment, but you also are not allowed to advocate for a family member's employment, even if you're not voting on it. You can't use the influence of your position as a board member to tell other people you should employ this person. You can't use your position as a board member to tell staff you should recommend this person for employment, to get them a promotion, or really anything related to their employment you're not allowed to participate in. There are some niche exceptions to this, such as with union negotiations. Some board members may have a relative in the union, maybe a spouse in the union, and you as a board member need to conduct negotiations with the union. What do you do if your spouse is in the union? Well, then it's a little bit of an inquiry as to what you're specifically negotiating on. The fact that your spouse or child or other relative happens to be in the union, on its face, does not preclude you from engaging in unions discussions, even though it's a family member. But it depends on how attenuated your negotiations affect their contract. For example, you would not be allowed to go into union negotiations and go to the other team, bargaining team, and ask, my family member X, I want them to get a promotion and I want to give them a $100,000 bonus at the end of this year. You don't get to excuse that discussion because you're in union negotiations. You are directly using the influence of your position as a board member to influence their employment and their position. But if you're talking about, say, for example, raises for, say you have a relative who's a teacher and you're discussing raises for teachers generally, and you're talking about the amount of it. The connection between your discussion of raises and the fact that you have a relative as a teacher, it's separated enough to where you can still talk about raises for teachers without violating the ethics law. And that, like we talked about, ethics law is ambiguous. So I can give this example, but even that example can depend on the facts. I talked about teachers. Maybe you're talking about a subset of teachers and there's only one or two of them and your family member happens to be one. And you're talking about the amount of money that you're giving for a raise. Then it's a harder sell. Then that may be a violation of it. It's an exception for union negotiations, but if you do have a family member in the union, call us. We need to figure out what's going on with negotiations, what may be happening. These exceptions exist, but because of the fact that they depend on the circumstances, we really need to flesh out what's going on when we decide whether or not there's a conflict or other violation of the ethics laws.
Keep in mind, John said, most of these issues are what I call after the fact. So in other words, if you've already engaged in these conversations that could be conflict, you can't undo them. And that's the problem. Okay. So that's why sometimes a little bit ahead of time. Union's a prime example. There's rules that differ. If, for example, Mindy Campbell's husband happens to be a board member here, you know, that's a separate issue. Or if Mindy's spouse is on the board and we're talking about a new supplemental for her. Okay, she's the only one of the bargaining that's going to get it. You know, those are sort of issues that you have to be really careful about. And some subtleties, I think, also with insurance.
Yes.
A spouse taking insurance. So there's a few things. Out of curiosity, trying to think, do we have any board members have children that are teaching in the district? I think we do. No, I didn't think so.
We've had board members with spouses in other districts, so these nuances have come up.
My husband coaches, but he's not a teacher.
We have one here, sure.
Danny Evil.
Yeah, Danny Evil.
Oh, yeah. The slide restates more of the same. There's a really common interplay between 102.03 and 291.42. The general principles I've explained are the same. Where it originates in statute really isn't too much different for how you'll navigate the ethics laws. Like we talked about, when a family member is an indirect interest, union negotiating the prime example, you can engage in discussions, but please ask if you do have a family member. Navigating this is complicated. One other point when we talk about nepotism and family members, I talked about the ethics law and the penalties that you may face for violating the ethics law. When it comes to specifically school board members and voting on contracts for relatives, there is a separate statute, 3309.21, which states the following. Whenever a local director or member of a board of education votes for or participates in the making of a contract with a person as a teacher or instructor in a public school to whom they are related as parent or sibling, or acts in any manner in which he is pecuniarily interested, such contract or such act in such matter is void. So in addition to violations of the ethics law for engaging in certain acts of nepotism, the contract itself is void under separate provisions of the law. Contract restrictions, I'll talk about them in a little bit more detail now. Ultimately, this topic in and of itself could be a much larger discussion, but to give an overview of what we mean when we talk about public contract restrictions. A public contract exists whenever a public agency spends money or money is spent for a public agency. I said that's a lot of things. We spend a lot of money as a district. We spend it a lot of things. It covers the entire spectrum of expenditures from legal services to simple goods like office furniture, all purchases made with public money or public contracts, written or unwritten, $1 or $1,000. 292.42, I believe I've already read this in the nepotism section. You cannot use the authority of your office to secure authorization of any public contract in which you, a member of your family, or your business associates has an interest. And similarly with nepotism, with family members or their employment, you would have to abstain from any decision, discussions, recommendations, and similar actions in which you, your family member, or business associate has an interest in a public contract. Even after the public contract is made, this prohibition extends to any actions that would affect the already existing contract. And it's the same thing with nepotism with the terms of your family member's employment.
And that could be a slippery slope. Public contract could be initial employment. It can also be renewal of a contract. So, they're here, but then you have the right to vote on whether or not you're going to renew that person's contract, give a continuing contract. It's the same sort of issue about not becoming involved when you get in those scenarios.
Really, probably the most important principle from that, your obligation extends, it's with the family member example, because it's the most common one. There's a reason we have a separate statute addressing it. If you have a family member of the district, your ethical duty extends for their entire time in the district. It could be years or decades.
So anytime like there's supplementals up, like I would just need to abstain.
Correct.
Yes.
And it extends to more than just voting, but yes, you would have to abstain, can't discuss it, anything of the sort really. Practically speaking, you should disappear when their name comes up.
But it's a good point as a new board member. Bethel uses what they call a consent agenda. They list 30 people and you vote one time. So make sure, that we pull that out. Because I know I got caught approving a consent agenda by accident. That's got a family member there.
And we know that.
Yeah, they're good.
I know.
Thank you.
Next, we'll talk about gifts. Gifts is it's a fun topic in the law, but unless you're getting offers for trips to Hawaii or $1 million checks, well, it's a little more boring.
I know, that's just like candy bar.
If you're getting them, we can have a separate discussion, but I'm making assumptions. Maybe I shouldn't be making. When you receive a gift of any kind, you ask yourself two questions. What is the source of the gift and what is the value of the gift? The ethics law prohibits you as board members from soliciting, accepting, or using your position to secure a substantial thing of value from an improper source. So the source, what is the source of the gift? Is it improper? What is the value of the gift? Is it substantial? An improper source is any person, company, organization, or entity that is doing or seeking to do business with the board. This includes things like parents, vendors, many different interested parties for you as a Board of Education. Any person, company, organization, or entity that is regulated by the agency, the official, or employee serves, students and parents, interested in matters before the agency, the official, or employee serves, students, parents, vendors. The theme is the same. Because you as a Board of Education regulate and deal with so many different parties, you have many different improper sources because many different people are interested in working with you. For what constitutes a substantial thing of value, this is the prime example of ambiguities in the ethics law. There is no line of a dollar amount I could give you to where now it's substantial. It really just depends on the facts and circumstances of you getting the thing and what the thing is. Substantial things of value are anything of monetary value that could have a substantial influence upon public officials or employees in the performance of their duties. Common examples, flights to Hawaii, meals at expensive restaurants, golf outings, season tickets to a sports team, jewelry, promise of future employment, travel, meal, and lodging expenses. However, small gifts such as a mug, mouse pad, promotional item, other things of nominal value, those are fine because they're de minimis, even if they're offered by an improper source. A really good example of this is the Capital Conference, the OSBA Capital Conference that's held every year. There are dozens upon dozens of vendors who want your business really bad, and they'll give you T-shirts, they'll give you flyers, they'll give you writing pads, other things of that sort. Swag. They'll give you swag. Those are all improper sources, but the things they're giving you are not substantial value. It's all de minimis. With that said, even small de minimis gifts, in theory, can become substantial if you get a lot of them. If I'm interested in doing business from the board and I give Andy a t-shirt, that's de minimis. It's probably not going to be a substantial gift. If I give Andy another t-shirt the next day and another t-shirt the next day and another t-shirt the next day, and I do this for the next 200 days, well, then the de minimis gift may very well become substantial. So when it does come to receiving anything of value as a gift, generally speaking, you can sniff out what is de minimis and what isn't. If you do, for some reason, have a question or a doubt as to whether or not it could be substantial, say, for example, you get a nice gift basket from a vendor or a parent. The value of the gift basket can vary. You know, some gift baskets are worth thousands of dollars, some are $10. It really depends on the circumstances of who it's from, why you're getting it, how many you've gotten, what the value of it is. If you have a question, again, call. But I think that's a great example of ambiguity. Gift baskets can be varying ranges of improper or not improper.
A lot of this can be and should be circumvented by a particular vendor. Instead of giving gifts to you, give gifts to the Board of Education as donation. And then you can decide how to distribute that among the staff, among the students. So you're not accepting a gift personally, and the Board of Education can accept it as a donation or even as a gift. No strings. They can't accept it and give it to Andy unless the circumstances dictate that. That's what that happens a lot. Vendors are charitable. They want to do something, even if it's a thank you as opposed to a bribe. But the truth of the matter is you need to accept that as a Board of Education. That makes things a lot better.
The last slide for our presentation, for better or for worse. The penalties for the ethics law. I outlined them earlier, but
This is where you're gonna have the jail on there.
yes.
Jail part.
I tried to talk him out of it.
To drive home the point, when we think about why do I need to follow the ethics law? Of the various provisions that we've talked about, violations of 102.03D is a first-degree misdemeanor with a maximum penalty of 6 months in prison or a $1,000 fine. Violation of the public contracts provision is a fourth-degree felony with a maximum penalty of 18 months in prison and a $5,000 fine. Violation of the supplemental contract provision is also a first-degree misdemeanor. And in addition to all this, in certain situations, such as nepotism hires by the board, those actions can be rendered void.
Okay.
Any questions on the ethics laws? Any comments on the ethics laws? Again, there is a good amount, a lot of information that we cut out of the presentation for the sake of brevity. Ethics laws in and of itself can be a 3-hour presentation. If you ever have a situation you think could raise an ethical question, give us a call.
Well, I'm simply exhausted.
Same.
Yeah,
Well, 7 minutes.
so appreciate the presentation. Are there anything just in general, any of the material that you wanted to talk about? And I know that you wanted to talk a little bit about committees still. So it's kind of refreshing. Come to the next one, sir.
I'm on.
You did it, you both did a great job. Thank you.
Yeah, do that outside.
I'm afraid he's going to put up their jail time again. So let's kind of start at what we've done for the past couple of years at Bethel under the leadership of Lisa Ford. You've had board committees. I think they were approved by the board. And I think you accepted nominations for board members, or you just appointed board members of interest on committees. Is that how typically work? And then I think you probably had no more than 2 board members. Okay. And those committees then were separate. I think you had transportation, technology, facilities, and maybe 1 or 2 other. Pardon me? Curriculum. So there's no reason you couldn't do that moving forward. The board would establish board committees. You would ask for volunteers on the board. You would work with the administrative staff. Then you would do, continue business as usual. Since the board would do that, now that you understand some of the rules, you would have to make it public. You would have to have agenda, circulate the agendas, and you would have to give minutes upon request instead of the conducting of those meetings. You can modify that if you want. You can have a board committee without board members on them. And since it's a board committee, you still have the sunshine requirements, whether you're on them or not. Or you could go to administrative committees, which is a little bit of a hybrid, as John just presented. You could have basically administrative staff. If you had board members come on those, it wouldn't be because the board appointed those, it's board committee. But volunteers could show up, probably no more than 2, but that would still be considered a board committee for purpose of the sunshine law. So if you don't want to go through the public part of agenda, public participation in meetings and minutes, it would have to be strictly an administrative committee. And then their agenda would be limited, as John said, so you're not circumventing the transparency of discussion. So they just come back and give you a recommendation and you approve it without the normal discussions. So you got those choices and maybe a few more, if that kind of helps your thought process. Oh, and by the way, if you've got 4 or 5 committees, each committee can be separate. 1 or 2 could be a board committee, 1 or 2 could be an administrative committee. Doesn't necessarily have to be an all or nothing with regards to committee format.
But the administrative committee has to be strictly business that the superintendent is, correct? Like would we be circumventing the system and saying like, we'd really like to look into, just for example, graduation or something like that, and we want your committee to take a look at it. Then is it board committee or is it?
Okay, I think what you're suggesting is you're giving an established committee a topic for discussion. They could certainly, do the research and then report back to you regarding options that you would have for the full board to deliberate.
For example, valedictorian.
Yeah, valedictorian, the grades, they could do the rules and the refinement, and not decision making. That would still rest with you.
That would still be a public discussion.
It would be here
Yeah.
when I would give
When
you
you present.
the update, like superintendent's work, I kept with those, those recommendations, what we've discovered, here's what we've got, what do you think? I think, buildings projects, the strategic plan, that needs to be a full board decision, right? But, curriculum and transportation, technology, graduate, those are all graduation falls under curriculum. We're going to talk about balance out.
Yeah.
I have my personal opinions of that. But those are, we did discuss that, but those are all things. There's probably not anything you would ask that I couldn't give a report on between us. I think from finances to academics to athletics, you'd be able to cover all that. If it's going to be a board member for say full transparency, then she's going to have to come to the board meeting. She's going to be responsible for the minutes. I just think that what do you want to capture here? What's the purpose? We will probably move quicker if it's an administrative committee because we're internal. We can get things done, and then I can present it out. I'm not going to make decisions without you. It gives you a lot of information. That's my 2 cents.
Is there a board committee that we have to have a policy one? Is that mandatory? Is there one, is there a board policy committee? Is there any in our board policy that we have to have?
And I would recommend you have a policy committee. You subscribe to a service, as most schools do, and I think, help me out here, we have maybe 150 sort of policies?
Well, we're kind of caught up now.
Okay.
When I got here, we were about 8 updates behind.
Okay, and what you do from the service, they do the legal research, what statutes have changed, federal, state level. And so you want to make sure as a Board of Education, you could do that as a board.
That's the only one we have to have, really.
Well, it's not even a legal requirement. You have to review policies.
So here's what's happened in the past. I've not had a board committee of policy, but OSBA, when they do policy, I look at the policy and I bring it to you all for a first reading. We have the discussion.
Okay.
What do you like? What do you don't like? Certain things we got to have.
Right.
And then certain things we don't have to have.
But if we have a policy committee, it has to be board.
Yes.
Yeah.
Same way with facilities too, correct?
If you're going to have a facilities committee, yes.
It has to be by
Yes.
statute.
Yes, and that's more for the transparency, because if you're making decisions and deliberations, you want the full board to participate in those deliberations.
Are those the only two that have to be, if we have that committee, they can't be an administrative, they have to be a board committee?
Well, you can have a facilities committee that's administrative, but it's a little bit different context. For example, when we built these other the buildings, there were weekly meetings with the architect, construction manager. There were some minor decisions that were made along the way. You don't want to wait for a Board of Education meeting twice a month
Right.
for those things. Authorizing change orders, things that, there's a hole in the ground, it's leaking water, it's gonna cost up to $3,000 to fix the pipe, you're not gonna want to wait. So certain parts of the facilities committee are administratively driven. Mike and Jenny will be in charge of that project to the point we're meeting with the architects, meeting with the construction manager at risk, and meeting with whoever else is necessary to drive the project forward. So in that sense, a facilities committee is not necessary. However, the design of the buildings, whether or not to put a K-12 building, a 3-8 building, whether or not you're going to put a field house or transportation.
That should be a full-blown work session.
That's a full board. It's not necessarily a committee, it's a full board process.
With the community.
Yeah, sure.
With community input, but that committee doesn't decide where the board's going. They
Well,
decide
as a
the
general rule,
recommendation.
committees never bind a board of education. No, that's correct. So now, I have a question.
Yeah, the facilities committee that operates today was established as a board subcommittee, if you want to call
Okay.
it that, with the board before me. So it's been established for a number of
Sure.
years, and we have the 2 board members that are on it. And we meet monthly. We have an agenda, we have minutes, we approve the minutes, and it's open to the public, and we have had a couple of people stop in. We have 12 members that have been appointed and appointed through the board and are captured in our minutes in the regular Board of Education meeting. And then our goal is to review the plans and also have some ideas and make some recommendations then back to the Board of Education. And that's our main goal, but it is operating the way a board meeting
That works.
should
The way you described it legally works, yes.
But shouldn't that facility committee, so we don't even have to identify it as a committee, if we're all working together to identify different things for facilities, there isn't even a reason to say it's a facilities committee, right? It's something we could discuss when we do these work sessions.
And-
Or,
In legal theory, you don't have to do the way you're doing it right now, but somehow you've got to have the Board of Education involved.
right,
Now, how you get your input, okay, I think what Natalie's saying, you're getting your input on facilities from the committee. So if you're not getting your input that you use as a basis to make decisions from a facilities committee, you have to find some mechanism to get that input. And it sounds like the facilities committee kind of wades through that, so you're not wasting a lot of Board of Education members' time going through an awful lot. They do a lot of the sifting for you, even though that's not necessarily binding. You don't have to do it that way, but somehow you got to get the information. If you don't do a facilities committee, then it's going to come up from Mike and Jenny after talking with the construction people. Either way will work. It's just a matter of a personal preference.
so if we kept it how it is right now, then wouldn't the board direct the facility committee on what we want done? Like, shouldn't we come out and say, okay, we need to look at where we're going to move the parking lot, or we need the committee to go and do some research on where's the best place to position an education center or whatever. Shouldn't the facility committee have a purpose and a direction from the board if it's a board committee versus?
Again, no right or wrong, Jackie. They would start out with a mission statement. Okay, here's the purpose of the committee. There would be an agenda, as we talked about. That agenda can be developed by a number of individuals, input from the board, parking lots, like you say, placement of a garage, or it could be self-generated by the committee itself, continuing from projects from day to day. But anyone can give input to the committee that goes on the agenda, yes. So if you wanted them to specifically research whether or not you're gonna move the parking lot L-shaped, straight out, or concrete, or, you know, whatever you want to do. That could be an agenda item. Or you could preserve it for yourself for board discussions, either one.
And I would think how a facilities committee functions. It could function differently depending on what's going on in the district. Let's say, I mean, right now, we're part of the system, if you will. If something would happen that would escalate that, then now we're in a different place, and how that functions might look different than how it has looked for the past few years. So I think what's going on in the district could impact that. Because you mentioned, like, administratively, we could get really, really busy with facilities, or not a lot. So, you know,
Well, and
depending on
and we
what
have a
happens
director of
in the next
operations now.
Yeah,
And he
Yeah.
attends the meetings.
yeah, David comes to those meetings. Like I said, the building projects I've done in the past, they were basically driven by work session and full board community historic.
And I could see where administrative facility committee would be like looking into the software to manage all the maintenance in the facilities. And getting, right, and getting Todd to figure out how to do recurring maintenance or those kinds of things that none of that would really fall on our lane. But we're talking construction, or what's the next step that FMD is going to take, or what facility do we need? Is it going to be on campus? All that would be big decisions that are driven by the board. And then that's where we could either identify it in a work session or somehow identify it to the committee. If that's what we want, right? But now you'd have to start coming to the facility committees.
Depending on how the minutes go, yes, I would have to look at how that all happens and make sure the notices, I just have to oversee everything and make sure that we're doing everything, because again, my name's on the line. So I'd have to just check and make sure.
Since
that
we have a director of operations, can it go to be an administrative meeting and then the board member, like, could a board member attend it? Like, I don't know. I'm just used to that's usually who runs those types of meetings, is like an admin. This is kind of new for me, so I just,
Well, if there's a board member there, though, it's important.
yeah.
And under our.
If we want full transparency.
I mean, abundance of caution, more likely than not. Two, I don't think Attorney General has any question. Two would probably be a board meeting.
Yeah.
One, you know.
So what do y'all want to do?
I guess.
Talk
first-
about it.
Yeah, what do we want the facility committee, well, one, do we want a committee, or do we want to run it through?
We have one committee that exists as a board, the facilities. So. I don't know if you want to do that. I don't know how you want to structure, you want to do that, and then you guide it, or do you want it to be a full board decision? That's what the work sessions are set up for.
It seems like as far as like the construction part works well in a work session versus, because we already get FMD comes and briefs the whole board, or CC comes and briefs the whole board. So rather than having them come and brief, like if they come to facilities committee and brief the facilities committee, and then they'd have to come back and then brief the board, it just seems like some of that big business could be done in a work session.
Which they have, that I think that they've done both, it's like
Yeah.
double duty. They went themselves and they can.
Or one, do we need a committee right now? Do we need a committee to work on something right now?
I think what Jenny alluded to is there's probably going to be some changes coming. that we're not officially aware of yet.
Right. I believe that probably in the next month or so, we might have a better idea of what the upcoming months might look like. And so what we might do is put together like a calendar of like, okay, here are the action steps that we're gonna need to.
And
be
what it might
doing.
do is totally change the agenda.
Correct.
That's what.
Yeah,
Well, we know what information we were waiting for to continue our discussions, pick up where,
And we're hoping to get that to you once we get. it,
right.
which will be
I know it was
soon.
more like a February timeframe and so, yeah, we were hoping to have that to review in a February meeting, but it wasn't available, so.
I would think it might be good to table this conversation. You know, maybe more information's coming.
I don't know. I feel like in the next week or so, we might have more information, which might guide our conversations a whole lot better without saying too much, but
We can definitely discuss. We got a board meeting in a week.
yeah.
We'll probably have an idea.
Again, we're just reviewing information and making recommendations. We've got 2 board members, we have 2 teachers, director of operations, we've got our maintenance person, director.
There's
Some other
definitely
people
gonna
from the
need,
public who volunteered.
right, there's definitely gonna be a need for input, right? I just don't know. I don't know. I think it makes sense to figure out how it's all gonna work together. And I know you mentioned monthly meetings. I don't know. I don't know if we'll have. We might need monthly meetings. We might need more, you know, I
I
don't
mean, I don't know
know.
if you've been through a building project, but then you built the
There's-
elementary, right? But they're time consuming. And there's a lot of meetings, there's a lot of decisions that you made and time is of the essence, so. You know, gotta move quick and you wanna make sure that you all know what's going on. So, and I think that, you know, your agenda moving forward for that committee may be totally different than what it has been in the past.
Yeah.
And when we were doing the new elementary building, the 2 board members that were on the facilities committee continued to meet. And again, with the maintenance director and now our directors of operations, we met weekly with the contractors who were doing the construction. And so we continued our role there and we're able to bring that information back to the board.
It'd be a good idea to wait and see what we get, have a discussion next Tuesday.
So right now, we have no committees, correct? Or does the facility committee exist till it doesn't exist, or is it every year we reestablish it?
How does that, what's the legal instrument? Because we didn't establish any in January.
If you're asking, does a committee evaporate every December 31st? I think that answer is no. You know, if they got a proper mission statement and a charge, then I think it perpetuates. If you've got 2 board members that were appointed, that may be a little bit different. You know, typically board member appointments are for a year. Legislative committee, you know, all the things that you probably did at your organizational meeting. Every year you do those again. So you may have a holdover of a couple of board members. You can remedy whenever you want to do that. But no, I think for the moment, what you have in place still functions until you decide to change it. With the possible exception of reviewing who the current board members are and whether or not they should be reappointed or volunteer in some official act for the calendar year 2026.
And then would they review the mission statement again and?
Well, the
And
data
bring
is
it
the
back.
5 of you. Okay, it's your committee. You would decide what you want that committee to do in 2026. But I think what I'm hearing from the administrative staff is that mission statement may change.
We don't know,
Usually-
we don't know now.
No.
So I guess that's my question, without the mission statement or like setting goals, really, there's no business required just yet for the facilities committee until we hear more from you guys. Is that?
But we have a mission statement. That's what we did in our first meeting when we kind of reconvened back in August. I think.
Yeah, again, it sounds like it's a functioning committee until it's changed. And a week from now, it sounds like you may revisit exactly what you want to do.
So maybe have the facility committee bring the mission statement with them to next week's meeting, and then look at that and see if the whole board is on board.
Well,
Or,
yeah, I would say this, with the information that we may or may not get, coming up, because I've been to some of them, I mean, there's, like Paul does a nice job, I just haven't been to all of them, right, at night when they're here, because I usually had something else going on. But with that being said, David's always here, I think we need to look at the information and then figure out where it's useful and what is the agenda. And then go from there. My opinion. What's worth. It's a lot of work and, time's important. If you're gonna focus on it, you wanna make sure you're on target.
There's gonna be enough work to do. We're all gonna be busy if it happens, so.
It's true.
so do you guys already have a meeting scheduled yet?
Yeah, we have it for the rest of the year. It's typically the second Wednesday of each month. So March 11th, I'm not sure exactly what day it was.
Oh, so you wouldn't have one before next week?
I'm
right?
sorry.
You wouldn't have one before next week, right? Until we get more information.
No, they canceled
Well, we can't,
February.
yeah, the one
Oh.
in February we canceled because we were hoping that we would have the additional information to kind of review and distribute with everybody. But as of right now, we're planning to have the one in March. It's really no different. Usually we spend 2 hours or so, 2 to 3 hours.
I think we got it Tuesday.
And they're recorded, thanks to Jason and his team, so.
I do appreciate that, because I go back and listen to them, so they're very helpful. So in the administrative committees, you can do whatever you want with those, right? I mean, you don't have to establish them, we're not involved in that, you do you.
Oh, we can do that, and like I said, we can just report back.
Right.
Yeah.
Or-
Well, that allows you to be more efficient.
Well, yeah, that's somebody internally that, like I said, they're great updates for you in the community, right? And say, here's an update, here's what we're thinking, give you input.
Right.
Everybody hears it.
And you task your people.
Then we'll do it, yeah.
Mhm. So really then, as it stands right now, we have a facility committee, which is a board committee. And
There are no
then
other
just
board
by
committees.
virtue of the policy committee is basically when Neola brings the policies to
Yeah,
us.
typically what happens,
The
we
first
sit-
reading.
I sit down with Mark and we go over what has to be in there, what I think is good for Bethel. What doesn't need to be in there, bring it to you all for a first reading,
Right.
send it to you ahead of time, because it's really riveting. And
I
so,
can't wait when I get my balls in.
then,
It's
and
really.
then you look at it, and then we discuss it, make the changes, go back. Put it back on for a second reading. And then once you adopt it, then we put it in production. Also. So,
So we don't need a board member at the Neola meeting then either, right?
no, because technically what, we said, it becomes board meetings.
So it's more thing.
Oh.
Then we
right.
need minutes, agendas,
Mhm.
which, I can knock out board policies with Neola and Jenny and whoever, depending on what the area or topic was during the day and get it out to you. So I always give you all updates anyway.
I think they're more efficient use of your time.
Mhm.
Yeah, I mean,
It cuts out redundancy of having a committee that reports to you, then you.
and the beauty of it too is like still it's a committee, it's a committee that does it. We're not having action, right? We're giving you, and I want input.
The first read of the
policy
policy at the board meeting is basically your policy committee.
Right.
Yeah, but the committees in general, I'm saying, I'm just gonna bring you, here's where we're at, what are your thoughts?
Here's what we're discussing.
I won't come back and say, this is what we did.
Or we have option one or option two, you have to pick this option or that.
We'll do what's required, what we have to do, and
Yep.
what's good for us,
Mhm. Okay.
if you want.
Mhm.
Yeah. Leave me out to dry.
Right now.
I'm already out.
Rolling, keep rolling.
Hey, he did say you have big shoulders, so.
Yeah.
He gave you a compliment.
Thanks.
Any more questions or comments, concerns? Anything?
John, I did have one question, and, John, you mentioned that the training's required. The legal training is required at the very beginning. Did you make that statement?
I didn't make the statement, but as board members, you guys undergo trainings for, among other things, you undergo training for the Open Meetings Act specifically, I believe. You have to undergo certain trainings as board members just to keep abreast of this stuff. And answer your question.
But
Do it every year.
So, here we go, write this one down. So I am your,
I think I
I
already
am your designee.
She
I
took
am
the
your
training.
designee for public records training, that 3-hour god awful training.
Unless you don't pay attention and you do the training.
Yes. So I am your designee, so when I did that online, I had to state each one of your names, so now you're covered because I did the 3-hour training for you. And you have to do that every time, like now, even if you did it when you were elected the first time, every new term, you have to have the 3 hours, so.
And also, this training is probably more than a good idea. You might recall 3 or 4 years ago, we got involved in a series of litigation. And one of the standard questions was, as your board member had training in the areas of Sunshine Law, Meetings Act, or policies. So now I think we can say yes, and we can actually point.
I wasn't here then.
Well, I don't think I've ever had it, and I finished 4 years, so
No,
I was gonna say
no,
thank
we
you.
I'm trying to write the ship, Natalie.
Yeah, that's fine.
Yeah, we're all involved.
Way more useful than trying to get online with a 3 hour.
Yeah. Thank you, Jenny, for doing that.
Yes,
because
thank you very much.
It's
Thank you for, putting it all
And
together.
thank you
for
both
us.
for the briefing.
Yeah, good job.
yeah,
Yes, it was very useful, very
it
helpful.
was really good.
Mhm, very
I mean,
helpful.
something not so great was okay.
We didn't even watch the clock.
Well, when I throw out, you can go to jail. You're
Yeah.
focus a little.
You thought of that.
That caught my attention.
I'm friendly my board.
I don't know where he gets it.
So that brings us to executive session.
Right, just
I
been
know,
trained.
I'm trained, she was paying attention.
She does it right.
So can I get a motion?
Wait, Jackie, do I get to ask my question or no? We're kind of at the end.
Go ahead.
It's a good one. So this is in relation to Jenny saying in the past at the district, you had changed your policy to say the recording was the official and the paper was the backup. So my question is, if you reference the recording in the minutes, does that cover you for anything not explicitly written in the minutes? And then the minutes would get approved by the board. Reverse it
You want
instead
me to
of.
handle that?
Go ahead, I can speak from experience, but I'm not an attorney, so.
Well, again, the minutes are only useful when the Board of Education approves them. So the fact that we have ancillary documentation here is helpful, but those are not minutes, unless the Board of Education can say, we have reviewed these, in our opinion, when we approve, that these are the official minutes of the Board of Education. So you can do the video, but again, the issue with the video is only that the Board of Education has to review that, and they have to maintain that officially, that these are them. Also, you get copies Someone wants a copy of the minutes, right now it's 10 pages long versus you have to actually give a person a copy. You can't just point to YouTube. You have to physically maintain your own video. So yeah, you can do all that. Whether it's a good idea or not, maybe involve further conversation. But I guess directly answer your question, Julie, it's not part of the official minutes, even though you have those available for inspection. It is a public record, by the way, but not part of your official minutes.
Even if you reference it in the minutes.
That's correct.
Because I thought the ORC said a recording was a sufficient legal.
Oh, well, it is. But my point, but you have to actually visit that and approve it. That's my point.
Okay.
Okay. You see, right now, just assume that you reference it in your minutes, and none of these board members ever see it. And it turns out the first 30 minutes of it were erased, or YouTube didn't record it. That's why you have to have accountability for that. But yes, you can do that. But you just have, as the 5 board members, have to have accountability that these are the minutes.
And if we have to review the video.
We would all have to
I'm
have seen the
sure.
video in order to
Yeah, the
approve
law
it.
says you should. Now, whether you're going to sit there with popcorn and watch it for 2 hours, that's up to you. Yeah.
We got time.
Or 1 minute.
Right.
On the agenda in the prior district, where it said approval of minutes, I would link the video as well as the written documents. And so when the board approved it, they were approving the video and the written document.
But legally, that would cover.
Well, it covers as long as the Board of Education viewed the video. Again, I might be a stickler on, how the statute reads, but it's kind of hard to prove something that you haven't seen.
But people do that with the minutes all the time.
I like to think that board members read those every word.
Jail time, that's
I'm
all
just
I'm
saying, but that's
thinking.
not a legal requirement. They don't actually have to read it, right? They can just say, yes, I approve it.
Of course,
But,
of course.
So my other question is, what can a board member do if others in the executive session violate the executive session rules? Like one example you gave was adding on something that you didn't say was part of the special meeting or part of the executive session. What can a board member do?
It's
So these guys know.
It's a little bit broad. Let me do a little bit broadly. When you get a board member who doesn't follow the rules, that could be one of them. The other one is a board member continues to do things, some things that we said you shouldn't do. You cannot discipline a fellow board member. The rules just don't allow for that. You can't even have a private executive conversation about a board member in executive session. As you read the 121.22 G1, except for board members and discipline, you have to have that in open session. What you can do is what they call a censorship, which can be effective. It's a proclamation or a resolution that, the Board of Education hereby determines the following. I'll use a Superintendent Nutter as a board member. Michael Nutter was engaged in the following activity. Please be advised that board members consider that a breach of our ethics and would ask him not to do it again. And that's part of the official record. That's as far as you can go. If it becomes a serious matter, you might recall 3 or 4 years ago, we had a couple of board members as part of the removal of office litigation. One of the things those accusations were executive session violations. So, if it comes to that, even though the court said that those particular the violations were not subject to for removal of a board member, those things happen as well. But beyond that, there's not much that you can do as a board. The board member violates its own policies.
Can like another board member say, this was not part of the executive session, we can't talk about it?
Well,
Or can,
what they should do is walk out. Okay, you should, knowing that what you're talking about, is a violation of the Sunshine Law. As your attorney, I would recommend you not continue those discussions. Just that simple.
Okay. So can I get a motion to go into executive session to consider the employment, dismissal, discipline, demotion of an employee or official, or the investigation of charges or complaints against an employee?
I second.
Any discussion? You take vote, please.
Mr. Beef,
Yes.
Mrs. Amberby,
Yes.
Mrs. Butler,
Yes.
Mrs. Donahue.
Yes.
Mrs. Leskowitz.
Yes. Right? I never say no, because then it's okay if we come back, but.